To point out the irony of Mr. Simon Bridges, the lawyer, standing up and being somewhat patronising to my very learned colleague, Lynn Pillay, and claiming that she didn't apply any legal rigour. Did you just point of order me?
Simon Bridges.
Fence at that remark being patronising. I normally am, but that speech was dead serious.
I would say to the honourable member, this is a robust debate. I think they take the words of your own colleagues, harden up a bit. We can't be that sensitive here. Maybe if the member had said you'd been matronised, you might have been less offensive.
Thank you. If I could put on record, I think that's the first time Mr. Speaker has said harden up in a point of order. But I just wanted to point out the irony of having delivered a speech calling on my colleagues to display legal rigour when the lawyer on the other side of the House stood up and basically gave no analysis to this bill whatsoever, which I found a little bit disappointing because I expected a little bit more of my colleague in that regard. But all of that aside, also for all of his comments that he made about my colleague Lynn Pillay, I'd have to say there's no one on our select committee that causes more of a stir in our meetings than Lynn Pillay. I don't think a meeting goes by that she doesn't defend the worth of the Sentencing Council, and I just want to put that into my speech now. The value of the Sentencing Council, which Labour will defend to the end. But on the limitation bill, I do want to come to a number of more serious points, because whilst this was actually a bill that generally there was a lot of agreement on both sides around what we needed to achieve with this bill, there were, I'd say, about 3 areas of contention that I do want to draw on, because these will probably be discussed in greater detail during the committee stages of this bill, but I want to flag them now. But first off, just to highlight again that we were reviewing a piece of legislation that had its origins from the 1950s. So obviously there were a lot of circumstances, a lot of things known to us in the new modern legal system which needed to be addressed in any new regime around limitations. And I think the things that we were trying to weigh up when we were discussing this bill was making sure that we balance the idea of giving certainty to defendants and reducing undue delay, with also building in reasonable grounds of which a claimant might have reason to have a delay in the claim that they were putting forward, or the case that they were putting forward. Before I get into some of the depth of the bill, though, I mean, we continuously hear from the government some criticism as to how long Labour may or may not have taken to put forward various pieces of legislation. And there has been this argument again that we demonstrated undue delay in bringing forward a review of the limitation bill. But when we are discussing a piece of legislation from 1950, I think that criticism could probably extend to both sides of the House. That having been said, I do want to just jump into those 3 areas that I already pointed out, where there were some more lengthy and robust debate within the Select Committee. And the first was around the long stop period. I know some of my colleagues have already discussed that. We did have divergent views as to whether or not, because the bill, of course, and the limitation bill sets out a 15-year long stop period, which is defined in Clause 10. And that basically means the time limit that would apply to your claim, whether or not that relates to personal injury, a civil claim, it could even relate to building and housing. But therein lies the rub. When it came to claims around the Building Act, I want to flag it again, Mr. Borrows, because I believe it was an important point, and as chair of the Select Committee, you'll know that this caused considerable angst for the opposition. The fact that we have inconsistency, and anyone who is a good policy maker, like the good sir, would know that inconsistency in the law causes some irritation. And the Building Act 2004 differs from the limitation bill in that it sets out a long stop period of 10 years. Now, we had some arguments put before us as to why that was important, that in fact defective building claims, that the complexity of the issues, fading memories meant that those issues needed to be brought forward within a 10-year period, that they would be known to the claimant within that period also. But I think the fact that the Law Commission, in 3 different reports, extending back as far as 1988, I believe, wavered in its view on this issue, points to the fact that there is room for differing interpretation. And my hope would have been that we would have erred on the side of caution with this particular provision, and also I would have hoped defaulted to the important premise of consistency. So that was the view that the Labour members of the committee brought to the table, and I would like to hear again in the committee stages a bit more discussion around the inconsistency in that area and what value it adds by having the 2 differing periods, because of course the national government has put forward its package of remedial action around, for instance, leaky buildings, which was the main set of cases brought forth to explain why we needed a different long stop period. And of course, they claim that that is a robust package. So I would have thought that there would have been nothing lost by building inconsistency between the 2. The second area, because there were 3 that I wanted to discuss, there were a couple of other areas that the Select Committee we did make changes, but these are, I think, the areas from my recollection we had more of a significant contribution to make. The second area was the discretion to allow relief for the claim of sexual abuse of a minor. Now, Clause 16 does give the court or tribunal the discretion to allow monetary relief to be granted in the respect of a claim of sexual abuse of a minor, even when a limitation defence had been or could be established. But we recommended specifically amending that clause to cover claims of non-sexual abuse of a minor, based on the fact that they could have the same long-term effects as sexual abuse. And I do think that this is consistent with where we have been heading in New Zealand, not just around sexual abuse claims, but around domestic violence, extending our definitions of violence, of abuse, in our domestic violence law. I think that there are a number of good reasons why that should extend beyond sexual abuse as well, and allowing more discretion, because at the end of the day this will be a judgment that is made before the court as to whether or not those monetary relief should be granted despite there being a limitation defence. And I think particularly when we are discussing cases which relate to minors, that provides even more reasoning as to why we should look beyond what otherwise would be a long stop period, because of the many psychological factors that are implicit in cases such as this. And we of course wouldn't be standing alone in making such a judgment. We asked specifically as a Select Committee to hear international evidence and good practice in this area, and we heard that the United Kingdom and many Australian jurisdictions do give similar discretion to disregard limitations in personal injury claims, which also include forms of abuse. So we are, I think, in keeping with other jurisdictions in this regard, and I think we've made the right amendments in that regard. I do want to touch finally on the third area, which I hope we'll have more discussion on later on in this debate, because I don't know that we've fully resolved this issue, and this was discretion to allow relief for claims of gradual process disease or infection. Of course, limitation applies to personal injury claims. It does factor in the idea of late knowledge. But we did express some concerns that the proposed long stop period could impose an unreasonable restriction on a person's ability to claim, particularly where gradual process injuries were involved. Now, the argument we heard back from other members of the committee and from officials, to be fair, was that because we have a no-fault insurance scheme in the form of ACC, that actually that we wouldn't see as many cases in this area anyway, because gradual process disease or infection is most likely to be covered